So welcome, everyone. So I'm going to have our panelists actually introduce themselves to you one by one. And I thought we're here sitting with songwriters and composers and publishers. Let's actually introduce AI through song and lyrics. So I asked everyone to pick a song, lyric, or a title that describes where you think we are in the world of AI and music. So I want to start with Emily.
Hi, everyone. My name is Emily CHAPUIS. I'm the Deputy General Counsel of the United States Copyright Office. We're the only agency that is dedicated specifically to copyright. So I'm really happy to be here with you all. The lyric that I chose is from a Rogue Wave song called Good Morning. And it says, "The future is not what it used to be. I'm not surprised."
There we go. Great. Thanks, Emily. Kevin.
Hey everyone, I'm Kevin Madigan with the Copyright Alliance. I'm VP Legal Policy and Copyright Counsel there. So I'm actually going to do not a lyric to a song, but a title to a song, and that is Virtual Insanity from the old Jamiroquai song, if anyone remembers that one.
Good description. Carletta.
Hi, good morning, everybody. My name is CARLETTA Higginson. I'm the Chief Digital Officer for Warner Music Group. I've only been there for 3 weeks. Prior to that, I was the Global Head of Music Publishing at YouTube. The song title that I chose was Janet Jackson's Control.
Ooh, I like it.
Good one.
Excellent. Dan.
I'm Dan SCHNAPP. I'm a partner in Sheppard Mullin and Sheppard Mullin's New York office. I'm also their AI team leader, technology transactions team leader, and music team leader. So I've been doing a lot of this and spent my entire career kind of on the transactional side, dealing with disruptive technologies, AI being the latest, greatest. I thought a lot about this, Nick, and I went back and forth. A whole new world came to mind, but that was a little bit too much unicorns, rainbows.
A little schmaltzy.
Welcome to the Machine by Pink Floyd. That was a little too dystopian. So I thought
like
Changes by Bowie was
perfect. Love it. Changes. Thanks, Dan. Anna.
I'm Anna GRESSEL. I'm with the law firm of Paul Weiss in New York, and I have been working on AI legal issues for about 5 years or 6 now. I started our practice, my old firm, in 2018, and I focus on all different kinds of AI counseling, regulatory, IP, litigation, for example. And I chose lyrics from Video Killed the Radio Star. The lyric specifically is, "Pictures came and broke your heart, put the blame on VCR." And I thought it was an interesting lyric for this point in time. VCR was obviously a big focal point in copyright litigation in the past. And I think there are always really important questions about how we litigate around technology issues, who's responsible, and what role technology is playing in our society that day, and then also how that's going to change in the future as the technology keeps evolving.
Great. Thanks, Anna. Thank you all. I tell you, for a bunch of lawyers, those are some really creative picks, so thank you. I'm definitely outnumbered by lawyers up here on stage, but that is the whole point. The point of this panel is to really try to demystify what's going on in the world of AI, what's happening in policymaking, what's happening from a legal case point of view, what's happening in commercial applications. This is complicated stuff. It's changing every day, but we have these experts up here to really try to demystify it. And I really welcome everyone here. This is such a great setting at the 1230 Club. I welcome everyone to raise your hand. We have mic runners in the audience. We'll have some time at the end for questions. But if there's something burning that you want to understand or you want to dig deeper into or you want us to move on, please raise your hand. We want this to be a conversation. It's like having a panel in your living room, basically, again, with a bunch of experts. So thank you, experts. So I want to start off a little bit, in this sort of demystifying way, just to level set, and so we all kind of understand a little bit more about copyright law. Like how does AI sort of challenge that? So maybe we'd start with Anna, all the way down the end.
Yeah, thanks so much. I mean, I think one of the things that we obviously have under copyright law is a bundle of rights in all different kinds of aspects of what we're creating. I'll turn this over to my fellow panelists who I think are going to be perfect to speak on these issues. But I think what we're seeing in AI is really a challenge to the way that we both recognize the contribution of that creation to a work that might be doing something very, very different than the original work. But also even how we recognize issues like, is there a public performance when you're using these technologies for all different kinds of things? They might be used to make pharmaceutical developments, for example, or used internally within companies for all different kinds of purposes, like searching their internal documents. These are technologies that can be put to work in a variety of different ways, and they challenge the concept of what the relationship is between the inputs to the model, the songs, for example, the lyrics, and the outputs, which may be actually used for functions that are far beyond the initial inputs themselves. So I want to turn it over to the other panelists to talk on this, because I think there are so many different ways to unpack this question.
Absolutely. Dan, do you want to talk a little bit about sort of how would you describe to a non-lawyer sort of copyright principles, and how does AI challenge that?
Well, in the AI context, I think the most important part is the exclusive rights, the bundle of exclusive rights that are implicated, most notably the right to distribute, the right to reproduce, right? So that's what Beth was talking about before, is a lot of these platforms are essentially taking your content, in this case, musical compositions and sound recordings, scraping them and reproducing them and making copies. There are arguments around whether that's fair use. We're going to talk about that in the copyright context, and that's a very complex question, and we'll get into why it may be fair use or why it may not be fair use. I don't think it is. But it's something that we'll talk about later. But I think at the end of the day, there are a lot of interesting questions. I mean, the Copyright Office is here, and I'd like to hear a little bit more about what they're thinking about whether an AI-generated work could be copyrightable at all. And I think that that's an issue, right? It's a question of how much human creators and their creative work and their generative work has actually been involved in that development. If there's not enough, and we don't know exactly what that gray area is and where that line is crossed, then the Copyright Office has said that that's not a copyrightable work and there's no copyrightable interest. So if there's no copyright in your work because it's been influenced by AI, that obviously is problematic for a variety of reasons, especially if you want to use AI to enhance some of your works and your creative process.
But I want to maybe back up even a little bit more. And speaking of the Copyright Office, we do have a copyright expert here with Emily. Let's just explain, like, what if somebody were to ask you, what do you do at the Copyright Office? Like, what is copyright? Like, and what are the rights that protects?
Yeah. So backing way up, I think it is always important to remember that the entire goal of copyright is to incentivize human creators. And the reason we do that is because the law recognizes, as I'm sure all of you do too, that creative output is a public good. So we are trying to figure out how do we do that best, and that's the same in the context of AI as it is with any other technology or any other new development. So at core, that's what we're looking at. In terms of sort of what is copyright and where does it come from, we actually have a copyright clause in the Constitution. And it says that Congress must make laws to protect certain exclusive rights of authors, and authors means any creators. And so Congress has done that through the Copyright Act and through a number of other laws, but it's all with this goal of how can we have more creative production and more creative works available to the public.
Right. Kevin, do you want to touch on that? Please.
I'm glad you brought up the Constitution, because I was going to start back there as well, sort of this foundational idea of these two goals. They're the two prongs of the Copyright Clause or the IP Clause, which is promoting the progress of the arts, but also how do you do that? By granting authors and artists certain exclusive rights that incentivize them to create. And I think the development of generative AI really sort of challenges the way we think about those two principles, like any new technology does. So like you think about the player piano, the VCR, like the internet, like all of these sort of jumps ahead in technology are always going to challenge those two goals of copyright, and oftentimes they're in tension. But I would say that like copyright law, in my mind, is flexible enough to confront those new technologies. And so like I'm not sure we need to say, well, copyright law needs to be overhauled or revamped in the case of generative AI, I think it can be applied to it in the same way it has with past technologies.
Anybody else want to, Carletta?
So the one other thing I want to point out is outside of copyright law, we also have other rights that are implicated with respect to AI and technology when you think about the right to privacy and moral rights. And so that's what's getting implicated from a name, image, likeness, and voice perspective. And that's not covered under copyright. There is no federal right that's across protecting against those interests. But when you think about deep fakes and the use of voices, for example, that have been generated via this technology that haven't been authorized and aren't used, again, that's another right that's implicated, and something that AI is completely transforming in terms of how we think about that space and what we need to protect from an artist and songwriter's perspective.
I think that's a great point because the actual biometrics in this data, in this content are different than just a piece of video, right? The voice and everything that is within a voice is a completely different ball game. I don't know, Anna, if you want to touch on that, or other types of rights that are potentially implicated, or for that matter, could be used for protection.
Yeah, I'll talk about that briefly. I think it's helpful to understand the difference between a biometric, for example, and a recording, just because I don't know how many artists we have in the room. I know there's a lot of fear of voice or image, for example, being used in a way that might misappropriate your name or your likeness. And biometric law, while it's not perfect, I think it's a really interesting point for everyone to just understand a little bit and understand where the regulations are going in this respect. So when there's, for example, if someone was taking a video of this panel, that would just be, a video recording of me. At some point, you could feed that into an AI model, and an AI model could actually make what's called a voice print or a face print of my face. Usually what that is a mathematical representation that's tied to my name. So my face print might have geometric representations. My voice is going to have a certain cadence and a certain set of mathematical vectors associated with it. If you take those, or if you take that kind of, geometric representation of my face and associate it with my name, that can be stored. It's almost like, your fingerprint that you use to get into your iPhone. Those biometrics, they have certain privacy rights associated with them. It's not across the board. It's in certain states, and there are certain states where you actually have to give written consent to do that. But the privacy laws, I would say, are not airtight on this. What is important, I think, for all the creators to know, particularly artists, is that there are increasingly proposals to actually require deep fakes or representations of people's likeness using their biometric information to be disclosed as such. So you couldn't necessarily pass something off as my voice or my image without actually disclosing that it's created by AI. That's not a perfect solution here. But just to be aware that your biometric information may have different kinds of rights associated with it than just your, a video of me from the panel, for example. But I don't know if other people want to jump in on this. I just think it's important to know that the rights go beyond the copyright context, certainly.
Yeah, I would just say that you also have to take into account that the rights, not only that you just described, are different from copyright. They also differ from jurisdiction to jurisdiction. So depending on, even on the privacy side particularly, if you're a resident of the EU, it's treated significantly differently than it is in the United States, although the United States is catching up on that front, particularly as it relates to biometrics and other sensitive data. But general, like, metadata about your compositions, they're treated differently and require enhanced consent in the EU to use it for exploitation and disclosure, where in the United States that's not necessarily true.
I think these are perfect examples, some of the principles that we talked about, transparency and global consistency, right? These are why we're talking about this so much, right? I want to talk for a second, maybe Dan, you could, or anybody else who wants to follow up on this. Let's talk a little bit about how AI works and some of the rights that are implicated from a training point of view, because I'm not sure everybody understands sort of how training works. Does anybody want to touch on that? Kevin?
Yeah, I'd be happy to. I like the question because I think a lot of people don't really realize that there's sort of two stages in the AI model process where I think there's infringement implications, and that's in the input/training/ingestion, whatever you want to call it, side, and then the output side. And so when I think about the copyright law implications for training, we're really thinking about implications for the right of reproduction. Are these works being reproduced or copied in furtherance of training? And that I should say that when I say input stage, I'm not just talking about the point of ingestion. I'm talking about the collection of works to create a data set, curation of that data set, because there could be reproductions made at any point in that process, as well as the ingestion stage. And so that's sort of an ingestion stage really is right of reproduction. Then on the output side, you have questions around the right to prepare derivative works. Is the output an infringing derivative? I think in a lot of cases, it won't be, but in some it could be. There's lawsuits that we'll talk about in a little bit that show evidence of substantial similarity. And then, there's other rights sort of that could be implicated with output as far as public performance or display, but that sort of depends more on how the end user makes use of whatever comes out of the AI system. That's sort of, if there's one thing I would say to remember is that there's two different sort of stages that you need to think about these infringement issues.
Right, sort of the input and then the output stage, right? So I want to talk for a second about something we hear a lot when technology and AI companies in particular are asked to defend their use of inputs, particularly on training. We hear something called fair use a lot. So I want to understand from our panelists, what is the concept of fair use and how is that being used or misused by AI technology companies? Anybody want to touch that one? Emily, you want to?
Sure. So there are certain contexts in which uses of copyrighted work are not considered infringement. And those include things like academic research that are sort of outside of normal uses for commercial purposes. So there was just a big case about this in the Supreme Court, and there's discussing the factors that you use to determine if something is fair use or not. I won't go into detail about what those are, but the argument that AI companies are generally making is not that they aren't using copyrighted works, or even that they're not exploiting them commercially, but that in doing so, that's fair use, right? That's a kind of training. Another issue that some of our stakeholders have raised on the creative side that people are concerned about is because of the fair use exception for research and teaching and scholarly work. One of the things that's happened in this area is that some of the data sets that commercial companies used were actually developed through academic research, and only later did they become commercial products. So there's a lot of people concerned about that transition from research to a commercial database and what that means for the fair use analysis.
And there are a lot of sort of cases that have been talked about in regards to fair use. Like we hear a lot about Google, right? Google Books. Does anybody want to talk about that? I think that's a good example. Or anybody want to touch on any other aspects of fair use so we understand that?
I think we talked about the Anthropic case, and we were going to touch base on Anthropic a little bit.
Sure. I'll quickly mention Google Books, because that is...
Let's talk about that.
So that's the main case that you see that AI developers and their supporters use when they say that training qualifies as fair use. And the Google Books case, for those who might not be familiar, involved Google scanning massive corpuses of literary works, books, to create a searchable database where users could search for a book. You get like a little snippet display of the book, and basically it would give you information about the book and perhaps point you towards somewhere where you could purchase the work. And that was found to be fair use. Now, I would say that in my mind, that's a little different than what's happening with AI, because these AI models are not being trained on copyrighted works to provide information about the work, or really to point you in the direction of buying a legitimate copy. I mean, they're using copyrighted works to train for the purposes of really manufacturing content that in many ways serves the same purpose as the work going in. So I think that's a really important distinction to make between the Google Books case. And as far as the Anthropic case, this is one UMG recently brought against this AI developer. And they provide some, I mean, I think it's one of the stronger cases that we've seen filed against AI developers, but one of the reasons is that they provide really clear evidence that the output when prompted, to create, or to, they asked it to create song lyrics, and it basically spits out verbatim lyrics, which is clear showing of substantial similarity that these things are capable and do manufacture infringing output. So I think that's, again, one of the stronger cases and one to watch to see how courts deal with some of these issues.
I mean, and it goes back to that sort of core principle in terms of training and what's being used to train the model. And whether or not, from a training perspective, the company, the AI system, had consent. Like, to me, that is the cornerstone in terms of, like from my perspective, from Warner's perspective, in order for AI systems to be able to, sort of use somebody's copyrighted works from a composition perspective, or somebody's name, image, and likeness, or voice from an artist's perspective, they should really have the consent to train using their material. And so, as a songwriter, as an artist, you should have the ability to determine whether or not your content, your name, image, likeness, and voice, your copyrighted materials, go into a model from a training perspective. Because on the output, you can have something that's generated that is either influenced by or specifically spits out something that contains your work. And so that ability to control and determine whether or not you want to participate is really a cornerstone in terms of this.
Yeah,
yeah, I agree with that. I think the fair use defense, at least in the AI context, really is going to fall on two factors. It's a four-factor test, but there are two factors that are really important here. One is whether the actual use that's being claimed as fair use is transformative enough from the original use to constitute fair use. And the second is the impact on the market for the actual original. Is it taking away from your creative expression and the value of that creative expression? And the bottom line is the platforms are going to have a very difficult time proving that. Especially given the case law that's come out recently, and obviously what's going on with the Anthropic case. I think they're going to parlay off of it. The Warhol case was a really tough one because it extended the.
Can you describe the Warhol case?
Yeah,
I'm not sure everybody knows.
Generally it was it's a case where you had the Warhol estate with the orange. It was an orange Prince. It was a print of Prince, and it was called the Orange Prince. And then it was used by another entity in various print publications. And they claimed that was just that was their photo, and the Warhol estate was infringing that use, and Warhol estate claimed fair use. It wasn't transformative. I mean, that's what the Supreme Court held, because it was the character of the actual use itself, the secondary use by the Warhol estate, wasn't different enough from the original, which is really to establish that print in the market. So in the music industry, it's gonna the large platforms, even the smaller platforms that are music-based and niche-based in the music industry, are gonna have a really difficult time saying that the purpose of their platform is not to create and distribute and potentially commercialize and sell and exploit a musical work that was trained on your creation. That's not a different use. That's not transformative enough.
Is there anybody who would argue against that on the panel?
I hope not.
I wouldn't argue
Just
against
checking,
it.
just checking.
Not with this.
This is about
Not this
dialogue. This is about dialogue. Yeah.
If I could just add one part about the Warhol case. So this notion of transformative purpose, fair use, was something that over the last 25 years or so had really come to dominate almost all fair use cases, meaning that courts were really focused on whether something was transformative purpose, and if they found that it was, 95% of the time, the ultimate finding was that it qualified as fair use. And one thing that the Warhol Supreme Court did was sort of rein that back in a little bit and say, okay, even if something is transformative purpose, that's not the end-all be-all of this fair use analysis. It's simply one sub-factor under the first factor under fair use.
Makes sense.
Yeah, I think the only thing I would add to that is, from a today perspective, we see a lot of the development of these large language models or other models within the hands of big technology companies. I know we'll talk a little bit about the future, but I do want to forecast that I think over time, particularly as the computing power you need to create these models goes down and the ability to do that kind of falls in the hands of more smaller companies. I think we are going to see companies that have different kinds of uses, different kinds of markets. We may see other big companies like in the finance industry, pharmaceuticals, create their own large language models. And the nature of these arguments may shift over time as the market particularly, I think, shifts for the discussion. And so it's important, I think, to keep in mind as we look at this that fair use can be seen through a lot of different lenses. Sometimes it's a product that is created by one company and commercialized by the same company. Sometimes there's a whole chain of companies involved. And so I just foresee this being a very complex analysis as these cases continue to wend through the courts, and one that is worth really keeping an eye on from a business kind of market perspective, looking at how that market is shifting.
Makes sense. So I want to turn topics a little bit, but I also want to remind everyone, if you have questions, put up your hands. We have a question right there.
Yes, excuse my ignorance, but you guys keep talking about transformative. What's the lawyer definition of transformative?
Could everybody hear that question? I don't know. The question was, what is the legal definition of transformative? We keep talking about transformative. And sorry, we're going to wait. I jumped too quickly at that question. We're going to send mics over to people. But anybody want to answer that? What do we mean by transformative?
Well, I don't think it's a legal construct. I mean, it is because it's part of what constitutes fair use, but it's a fact-based decision at the end of the day, and there's no fine line. I don't know if the Copyright Office of the Copyright Alliance has any specific insight in it, but the fair use defense is a case-by-case analysis, and it's different for every fact-based, specific, context that comes before a particular court that's deciding it. Transformation means it's got to create something unique. So you have some original work. They're claiming that they don't need your consent to use it because they're transforming the use into something new that has some benefit to the public.
Which is also something that we think about a lot in terms of art and creativity, right? There's a lot of art based on other art. So it's not just a legal concept, but it's also a creative concept in many ways too, I think.
That's right. And one part of it is the more transformative something is, then it's supposed to have it's less likely to affect the market for the original work. So if something's highly transformative, whether that's aesthetically or for a purpose, then courts will say, well, a consumer is not going to gravitate towards this potentially infringing work because it's so different than the original that it's not going to affect the market for that, and that's one of the reasons why it would be considered fair use.
I think the final thing I'd add is the most important decision recently on transformativeness was the Warhol decision, which said you can't just add something to an original work and say that it's now transformative. It has to do something fundamentally different, or else this would just collapse back on the question of whether it was a derivative work. It added something, it was a derivative. Transformativeness needs to mean something different than just additional content, additional kind of meaning. And so I think that's really, a big part of the question as we look to the future is something transformative because we're changing it, or is it transformative because it's doing something different? It's accomplishing a different purpose. And how do you decide that in the machine learning context where you could have one model with 1,000 purposes or 1,000 uses, or is it just one? And so I think we're kind of this is what I was getting at earlier, we're getting at these interesting questions of, does a model have one purpose? And if it has more than one purpose, does that add, does that transform? I don't think people know, really, I don't think there's one answer to that right now that everyone's aligned on, but it is going to be the set of questions that people are asking, and the Warhol case is kind of the major directional shift that I think we've seen recently. And certainly, I don't know if that's fun reading, but I think it's potentially interesting reading.
Certainly interesting. And I think that makes a lot of sense. And thank you, everybody, for those explanations. Every case may be very different, right? Every AI platform or engine may be very different, have different purposes, have different applications. So there's not kind of one one answer to sort of fit all questions necessarily. I do want to turn a little bit to a slightly different topic. We've talked now about sort of what are some of the rights that protect us all as creators, and maybe some of the defenses that we're hearing from some of the AI companies that are utilizing our content. I want to talk about kind of where we go from here, and really sort of how do we, from a policy point of view, and then we'll talk about it from a commercial point of view, from a policy point of view, how can we create more guidance for our creators, our ASCAP members, and more broadly speaking out there? And I think, in our little copyright corner over here, I want to ask Emily from the U.S. Copyright Office a little bit about their process, right? Because there's been some previous guidance that the Copyright Office has issued, but the Copyright Office is also right in the middle of a very major undertaking, the NOI, Notice of Inquiry process. So maybe could you tell us a little bit about what is an NOI process? What is the purpose of it? How will that work? And what do we think the outputs are going to be? Because I think there are a lot of people waiting to understand where that is netting out, maybe even before other legal implications and other legal proceedings. So you want to talk about that for a little bit?
Yeah, and I'll just start by saying thank you for that question, because I know it's easy for us to slip into legal speak, so please interrupt me if I do that again. The Copyright Office has undertaken a major artificial intelligence initiative. You all know that this is a huge issue for all creative communities. So we announced that at the beginning of the year. We have been endeavoring to get all of the information that we can get from all stakeholders through meetings, through going to events, through holding events ourselves. The first major report that we did was that everyone's sort of been mentioning, was issued in March, and it's guidance about copyrightability and AI. So as I sort of mentioned before, the big question that we're looking at in terms of copyrightability is authorship, right? Does a work have to be created by a human author? When we say author, do we mean human author? Or do we also mean machines? And what the copyright policy guidance says is, no, we mean human author. And if you want to copyright a work, it has to be made by a human, not just generated by an AI system. So I do want to be clear, though, because I think there's a lot of misunderstanding around that guidance, that what the rule is not if you've used AI in any way as a tool or in any part of your work that it can't be registered. Instead, we are looking for enough human input and enough human creation to make it an original work, to make the human an author. So, we've seen cases where someone tries to register, one of the big ones, someone tried to register a comic book where the person had written the text but used AI to generate all the images. And in that case, the images aren't copyrightable, but the part that's created by a human still is. So disclosing your process and what you've done allows us to say, you can't have a copyright in the whole thing, but you can have a copyright in this part. You can have a copyright in the compilation or arrangement as a whole, even if there's parts of it that are AI generated. So we have asked people to disclose when they're submitting a registration, which parts are human created and which parts are AI created, and that allows us to sort of draw that distinction and follow up and ask you if there's questions about it. So that was step one. And now we have issued an NOI, Notice of Inquiry. And what that is the office has just put out a set of questions and asked the public to comment on them.
A long set of questions.
A very long set of questions. It's 34 questions plus some subparts. So, but we want that input. So the questions fall into 5 general categories. So one is more about this copyrightability question. Another is about training or input. So you've heard about, is it fair use or is it infringement? But then also, if using copyrighted works to train is infringement, what do we do about that? Who's liable? Is it the person who created the data set? Is it the person who created the AI product, right? Who owes creators something? And also, if creators are supposed to be compensated for those uses, how does that work? when you're talking about ingestion of millions and tens of millions of works. The second category is outputs, right? How do you assess whether the thing that pops out of the AI tool is too similar to a copyrighted work, such that it's infringing. The third category is data and transparency. So both, do we need laws requiring companies to disclose what they're using, what works they're using in this process, and also, do we need laws requiring them to maintain the data that would allow them to do that? And the last category is what I think of sort of copyright adjacent, but how do we protect other things like your name, your image, your likeness? And one thing that a lot of creators have also told us is important to include in that category is your style, right? If an AI tool is trained on your work and then creates something that looks a whole lot like you did it, what does that mean in terms of potential liability? So those are sort of the questions that we've asked. I'll make a plug too. If you have opinions on any of that, not on all 34 questions, but on anything AI related, we would love to hear it. The comment period is still open, and we get tomes from big organizations, but you don't have to be a big organization. You don't have to be a lawyer. We also get a lot of comments from creators saying, this is what I'm worried about. This is what you should be thinking about. This is how AI is affecting my business. So that's been really helpful for us.
That's a great explainer, and I would echo what Emily said. And first of all, by the way, I was joking about the long set. I think we and everyone in the community, the business community and copyright community and creative and I think technology community appreciate how many questions there were. No, I'm serious. We spent a long time. So ASCAP did respond to this with a very lengthy submission, trying to bring together our insights from our members. From our analysis, from all the research that we did, but they were really thoughtful questions, and it means that the Copyright Office is really thinking about this carefully. So we're very appreciative of that. But there's a lot to it, and there are a lot of good questions. But I would echo what Emily said. If you have opinions, we want to hear them at ASCAP as well, so we can continue to relay them and amplify them as we go through this process. So I want to just so what's going to be the net result of this? Do you have a sense how many responses you've received already?
Do you want to tell them how many responses you've gotten?
Yes. So there's 2 opportunities to submit comments. The first opportunity just closed, and we got about 9,000 comments.
Wow.
All of which our staff, our human staff, will be reading one by one. So we are in the process of doing that. But again, it's because we really want to know what people think. They're hard questions, and we certainly can't figure them out alone. But it's a lot.
Yeah, that's great.
And to answer your question,
what happens next?
What are we going to do with it?
Yeah.
So we spend a lot of time analyzing comments. Ultimately, we do a couple things with them. We use this information to advise Congress and the courts and other federal agencies to provide technical advice. And there's different ways of doing that, but I think for this, there'll be at least one written product, potentially more. It's a big area. We haven't announced a timeline for that. We're obviously still in the comment period. But we will be putting out something that looks more like the copyrightability guidance that people can rely on. Yeah?
Mike.
Comment, and it behooves us all to comment. In the second phase, where and how do we do that?
Oh, sure.
So the question was, in the second phase, how do we comment, right?
Yeah.
And how? When?
So all of the information about our initiative is at copyright.gov/AI, and it has a lot of other information, but it'll direct you both to the questions as well as give you information about how to do that.
It's November 29th or 30th, I think?
November 29th, yeah.
Right.
So what's happening at the Copyright Office is obviously a very significant... Oh, is there another question over here? Sorry, I can't see it. Thanks.
Hi. My name is Bobby Hamrick. I'm a writer-producer. So generative music is not new. Composers like Steve Reich, Brian Eno, John Cage have been influential for generations now. Of course, that didn't involve machine learning. I'm wondering now that AI, machine learning, advanced language models that's out of the box, what are some positives that you see going forward, if any?
Yeah, so there's definitely, just to talk about a little bit about what we've heard, we have heard that, right? There's artists that are using AI in really creative ways.
And that's our second panel topic, so we'll have lots to talk about on that.
You know, another thing that we have heard is that AI can be really helpful to artists who have disabilities but still want to express their creativity in ways that might be hampered by their physical limitations. I will let the next panel handle a lot of that, but that's a great question. It's not all one-sided, right? We're hearing positives and negatives from creators.
I have tons more questions, but I really want to open it up to everyone here because I think there are a lot of questions, and we all want to hear from you all. So is there a mic? Great.
Okay, so my name is Amber Sweeney. I'm a singer-songwriter. I'm actually doing some freelance with a company that has asked for a sample of my voice for this purpose. And so I guess part of my question has to do with, you mentioned biometrics earlier. You mentioned being able to, kind of pull, certain voices to use to pitch songs and things like that. Do you see something in the future where we're going to be able to actually receive royalties for that? Are we going to be able to track that kind of like we can track our songs as they're being played on streaming services and things like that?
So just to repeat that, Amber asked, a company had asked her for a vocal sample, and she'd asked, in the future, are we going to be able to receive royalties on our vocal samples, as an example? All right.
Well, I think you should, right off the bat, negotiate for a royalty for that. But automatically, I think that's coming. I think that's what we were discussing last night amongst ourselves, because we've been in the business for a long time. We can't wait for the law to catch up to the tech. It never will. It never has. It never will. And now this is the most disruptive, transformative. I hate the pun, but it's true. Disruptive technology that's hit this industry and the creative industry generally in our lifetime, and it's growing exponentially. So the problems that you have right now are really about attribution and their economic issues, right? Of making sure that you're compensated for the use of your works without your authorization. These models need to be trained on enormous amounts of data. It's not necessarily practical for them to license all of it. It's not going to happen. There are different ways you can do it through PROs, right? Collection societies that have infrastructure and relationships with a variety of stakeholders in the industry. But it's probably going to be solved by technology. And you look to analogous issues that we've had in the past, like UGC with YouTube and Content ID, and there was nothing like digital fingerprinting, 20 years ago. And now all of a sudden it's an industry standard, and there's a way to identify a rights holder's interest in a sound recording in an audiovisual work. I think in the future, and not too distant future, there'll be a way to identify your name, image, or likeness in any particular work that's created by generative AI through some technology. That doesn't exist today, or it may exist in a lab, probably in one of the larger organizations and technology platforms, the DSPs, that are working on it right now. And they understand that, and they're working with industry, and it's up to us to make sure that we bridge that gap.
I think that's absolutely right. And the only thing that I would add to that, because I think that 100%, we're fighting to get to a place where that identification is happening, and that there's some sort of watermarking or there's some sort of way to track that back so that, we can understand and see. And once you have that identification, then you're able to sort of have the monetization that flows from it. I think it still becomes critical while I completely appreciate and do think that it's going to be the commercial discussions that lead right now, and those are going to be the things that are moving fast and moving forward in a way that allows us to address it immediately. But the regulatory nature is also going to be so critical, because what happens is these technology companies, they will build because there is liability, because there is regulation that is that's sort of underpinning this. And so when they feel that pressure, and when there is that sort of balance between the pressure from a liability perspective, there is more incentive for them to build the right protections and tools that are necessary. But it really is those commercial discussions that'll drive.
Yeah, I mean, just to add to that very quickly, you saw OpenAI come out with their principles yesterday in their developer conference saying that we're going to indemnify every user of our tools, of our developer tools, from any claims of copyright infringement. And it's easier for them to do that because they have a ton of money to do that, and they're going to have insurance to back that up. There are plenty of insurance companies that we're talking to right now and carriers that are underwriting that risk or are planning to do it because it's a big market. It's easier to do that than to engage and license directly. So you're right. It's got to be a combination of regulatory principles, ethical principles, regulatory legislation, and some holdings that have come from the courts, but at the same time, I think it's going to be solved commercially.
Yeah, I want to see if there are other questions. Anyone? Over here. Great. Question over there. Mike over there, please. We just have a few minutes left, so if you have a burning question, make sure you get ready.
Hi, my name is Alan Brooks. I'm an artist that goes by Werewolf. As we're entering the age of AI, you guys have discussed the positives and the negatives as creators for AI. Have you guys seen any, felt any impact on AI in your lives, positively, negatively? You can share your experiences with AI so far.
Let's make it personal. How has AI affected you all?
I can jump in. I mean, I think, the legal industry has a lot of questions about what it's going to look like to have a workforce in the future with AI tools that might replace some of our younger lawyers, for example. There really is a sense of both promise that the tools might make our lives more efficient as assistive tools, but also a question of, what the economic model is of law firms if, a lot of our junior lawyers could frankly be outpaced by a tool that could do their work better than they could. And so I think every industry is really thinking through this right now. I don't think music is alone. Obviously, we're talking about screenwriters, we're talking about actors, but I think in finance, all across the industries that are adopting these, we see workforce questions really come up. And that's, it's a topic that the White House has asked for questions on. So certainly I think the music industry is facing these questions in a really important way. It's not the only one.
It's really every industry, frankly, and I think no part of our life is going to be untouched by this. So I have one more question. I think we have a question back there. Do we have a mic? Mike? I think this will probably be our last question.
This may seem really weird, but you know how we can be talking around our computers and our phones and then certain ads come up when we've talked about things, right? So as songwriters sitting in a room with our computers sitting there and our phones sitting there and all of the things we're talking about and titles and all this kind of stuff's going inside there, do we need to be shutting all that stuff off when we're in the room? Like my name's Carolyn, and if somebody said, I want to write a song, it's a heartbreak song in the style of Carolyn Dawn Johnson, can they somehow with A&I go into my computer and know what I've been doing for the last 25 years of my career?
Well, that is a question we all want to know the answer to. But I would love to ask amplify that question with sort of what concrete advice would we give our members how to use AI, how not to use AI, in what environments, any other really concrete advice that this panel would want to give to songwriters and composers and publishers?
I would say there's a couple of things that you can do, particularly if you're a songwriter using a tool. You have to read the terms of service associated with that tool because they're all different, right? The tools don't operate the same, and they have different risk allocation, and tolerances for risk. So, for example, they're just straight ownership. Whatever you might put into an AI tool, one AI tool may say, well, we're going to have a license to exploit that in any way we want, and you can't negotiate these things, so you got to be careful. Another one may say, not only do we have the license to use it, we can, for this purpose, we can, license it back to you for a limited purpose. So now all of a sudden you gave away a right, and you don't have those rights that you have to use it for another purpose. So it's very important from an ownership perspective to read the terms of service. I think, especially when you're, and I think the Copyright Office would echo this, document what you're doing. right? Make sure you understand that when you're going to register your copyrights, at least in the United States, you have to disclose exactly what's been created and how it's been created using an AI tool, for example, or what level of input. Sorry, I'm competing with sirens. What level of input you created or that you put into the input itself is really important in terms of whether it's copyrightable at all, at least at this point in time. So, and then the tool itself, is it a tool that is just spitting out compositions or sound recordings based on your input automatically and indiscriminately based on what it's been trained on? Because if it is, it's probably too indiscriminate to create something that's copyrightable in the first place. So you got to be careful about the type of tool you're using, the terms surrounding that tool, and the documentation and substantiation of your work as it relates to the use of that technology.
And I would say that applies to every type of technology, including whatever listening devices, phones, et cetera, you might have. Read the terms. If you haven't watched Black Mirror this season, you might want to watch the first episode. It talks a lot about reading the terms and conditions and what might be listening to us in our world. So thank you for that last question. I think we had another question over here.
How you guys doing? So I'm a hip hop artist myself, and I seen something where Drake and Future are getting a Grammy for an AI produced track. Now, is that one of the ways that are the award people accepting AI as a human? Basically, what I'm saying is, like, as humans, can we make our music and an AI remix it or whatever and win awards? How true is that?
Does anybody want to talk about the Grammy regulations? Is that what you're talking about, the Grammy regulations?
Be surprised that they actually recognize that. But I don't know what ASCAP's doing. ASCAP's got awards. What's ASCAP doing, Nick?
Yeah, so I mean, I guess from an ASCAP perspective, we know that our members have used AI in lots of different ways for years, frankly. It's not new technology. There's AI built in all sorts of things. So we would not give an award if AI was used in a work. However, back to our principles, there has to be a human creator. And I think similar to what we've heard from the Copyright Office, that impact, that creative control and creative output has to be human driven. So again, human creators are at the center of what we do, and that's critical for us in thinking about awards and anywhere else. So I think with that, thank you, everybody. Thank you to our panelists. Everyone, please give a hand to our experts.